I submit to the court that the defendant should be permitted to use special measures, specifically an intermediary, for the duration of the trial, including to give evidence. The issue of special measures for defendants is introduced in Section 104 of the Coroners and Justice Act 2009, which inserts into the Youth Justice and Criminal Evidence Act, the YJCEA, Section 33BA, which is the use of an intermediary for the defendants when given evidence. In this case, it would be subsection 6 that applies to Rashid, in that the accused is over 18 and it could be said he had a significant impairment of intelligence and social function, and for this reason is unable to effectively participate as a witness, giving oral evidence in court. This statutory power, however, is not enforced yet, so a judge's power to appoint one is governed by the court's power at common law. At common law, the Court of Appeal Criminal Division recognised in R&H that the courts have an inherent right to appoint an intermediary to help a defendant follow the proceedings and to give evidence. If without this, he would not be able to have a fair trial. Support can also be found in the secondary sources of criminal evidence law, the criminal procedure rules. Rule 1.11 sets out the overriding objective, which is to deal with criminal cases justly, including recognising the rights of a defendant, particularly under Article 6 of the European Convention of Human Rights. Furthermore, the court's case management powers in Rule 3 require the court to consider what arrangements are necessary to facilitate the participation of any person in the trial, including the defendant. Moreover, it is said that the court needs to take every reasonable step to facilitate this participation, including enabling a witness to give best evidence and enabling them to understand the proceedings in order to engage fully with their defence. Another protection of the defendant's special measures is seen in the status of their right to effective participation as an Article 6 guaranteed right. Given that equality of arms is a characteristic feature of a fair trial, especially concerning the adversarial model of UK court proceedings, I propose that the denial of an intermediary for the whole trial makes the parties notionally unequal. The case of SC and UK provides the most comprehensive description of effective participation, which includes the right to hear and follow proceedings. The ratio of the case, Dririoj and Turkey, established that the defendant has to have been placed at a disadvantage regarding the defence of his interests. Rashid's low intellectual ability would have impaired his right to follow proceedings, resulting in an unfair trial. One of the reasons that Rashid would benefit from an intermediary is that though he might have been found fit to plead, this does not automatically guarantee his effective participation in his trial. There is a distinction between these two concepts, as explained in R and West London Youth Court. Although this distinction is not consistently understood, as is evidenced by the differing opinions of the medical experts, the fact that one of these concepts is a right encased in statute is especially important in finding that the defendant should have an intermediary for the whole trial. Dr. Locke's report is problematic. It didn't address the defendant's mental vulnerability, and it said that he was fit to stand trial because he understood what was put to him. This doesn't translate to effective participation automatically, especially if the other medical reports suggest that the defendant presented himself as more able than he actually was. Furthermore, the average IQ of the person is between 90 and 100, and although the experts disagreed on what Rashid's IQ was, their respective submissions were still less than the average. Adding this to the fact that fitness to plead and effective participation are not the same thing, I propose that the judge should err on the side of caution and on the side of protecting his Article 6.1 right. It could be contended that the judge rightly and reasonably adapted the court processes by accommodating the rare use of an intermediary while he was being examined, which does prioritise the foundational principle of accurate fact-finding. However, whilst jury examination might be when the intermediaries are most useful because they are points of the most stress, it's not the only time where there would be need for them. The other need for intermediaries, as distinguished by Lady Justice Rafferty in the case of OP, is one of general support and interpretation of unfolding events. Therefore, I would propose that Rashid need an intermediary on the basis of general support as a safety mechanism on the chance that his IQ actually is lower than average, which would impact his understanding of what was going on. Furthermore, consider the makeup of the courtroom. The dock makes it difficult to instruct your lawyer and to sometimes hear what is going on, which deprives the defendant of the personal right to follow. Furthermore, effective participation isn't always guaranteed even if the defendant is of a normal IQ range. The Ministry of Justice 2015 reports found that it's not actually in practice expected of defendants to follow adequately. Therefore, it follows that for a person with a diminished IQ, this would affect Rashid adversely. Having analysed this distinction between the fitness to plead and effective participation through the lens of the equality of arms, I would propose that the denial of an intermediary for the duration of the trial would be a breach of Rashid's right to a fair trial. My second argument is that I disagree that the role of an intermediary can be superimposed onto the obligations of the defendant's lawyer so long as they have the professional capacity through training. The case of Aaron Cox suggested that judges are expected to deal with specific communication problems during the judicial process, communicated to them by the lawyer on the defendant's wishes. However, if the defendant cannot follow the proceedings because of aforementioned impairment to their intelligence, the likelihood of them informing a barrister who will then inform the judge is low. Pardon me. Furthermore, regarding the issue in OP that the judge makes the intermediary assessment on the basis the advocate has undergone specific training to establish their professional competence is problematic. There is no specification of what this training is. The communication suggestions, such as short sentences that Alex met her set out, are nothing but recommendations. In practice, ensuring lawyers adhere to this is not always enforceable. And it is said that if a lawyer was seen to have lacked training, the remedy is to inform the defendant and the relevant legal authorities rather than impose the costs on the court by appointing a new intermediary instead. This is unnecessary bureaucracy and administration that would prolong an already lengthy court process. This could shake public confidence in the justice system, not just by delaying convictions, but also in its telling of the weakness in the infrastructure of the system in that it prioritises costs over the interests of justice. On the issue of costs, because the defendants are excluded from the registered intermediary scheme, unregistered intermediaries cost more as there is no fixed scale of payment. Therefore, the firms may charge higher fees. Defendant intermediaries should not be paid for by the central court funds, as this is only a benefit that applies to witnesses who have intermediaries under Section 29 of the YJCEA. However, it could be read into the court's case management powers that this might be their responsibility to fund in order to ensure effective participation, which might be the reason for their reluctance. I understand that effective participation is a cloudy field for judges, but discourse is necessary to make sure that the defendant is treated as a subject of the proceedings rather than an object for the imposition of conviction and punishment. Given that their right to liberty is at stake, this would be an unethical and unstable way to use the justice system. I understand the effectiveness of special measures in trials isn't conclusive, and it would be an expensive way to trial and error the use of intermediaries if the judge erred on the side of caution every time, but until the statutory provisions become effective, it remains under judicial discretion and their responsibility to weigh up the balancing factors. This lacuna of statutory ambiguity is filled with the judge's wide scope of discretion, which is why I would also disagree that the role of an intermediary can be fulfilled by a judge. The judge stated that giving the defendant an intermediary while they gave evidence was overgenerous, and this bolsters what academics such as Owusu Bempa suggest in that, because of their familiarity of criminal proceedings, the judges might underestimate the difficulties that people may face, and this might be met with scepticism. In the case of CPS&P, the judge is not bound to accept medical expert opinion, but neither is a judge an expert in psychological matters himself. Lady Justice Smith stated that medical evidence on understanding should be reviewed in conjunction with other evidence alluding to understanding, in this case his educational background. However, the defendant only passed his GCSEs a second time with the help of a private tutor, and the fact that his education was fraudulently obtained due to fraudulent documentation says he would not have gained admission to university with his undoctored grades of unclassified, and his lack of progress in his studies at the bottom of the class, I would say, therefore puts his educational level as one of a 16-year-olds with poor grades. With all due respect to the judge's expertise, in the case of Rashid, I find it puzzling that the medical speculation as to his IQ, coupled with the academic record that is decisively weak, was rejected over the conclusion that the judge obtained from watching the videos, gleaning that he was competent enough, and this was enough to reject the medical opinion. It is on these grounds I propose that Rashid should have had an intermediary present for the duration of the trial.